And that, I mean, that also kind of ties in to we have a sort of a litany of questions, both from David and then a few other members about Weird Beard, that they want to know, what are we thinking in terms of the Supreme Court? Are they going to take more cases? What are the odds that they're going to take the, Illinois assault weapon ban case after it's decided by the Seventh Circuit? Do we think the Supreme Court's waiting to combine a few Second Amendment cases at once to issue just one sweeping ruling? I don't know. What do you think? It's like you answered part of it there, I think, in your previous answer, but it's tough to say expecting the Supreme Court to make up, all this ground in a matter of a year or two, right?
Right, certainly. And you have one. They're not going to take any more Second Amendment cases for this session like that. They're done on the regular docket, at least, for the cases they're going to take up. There's some speculation that they could, take up Range, the nonviolent felon case out of Pennsylvania, and sort of combine that with Rahimi, which is the domestic violence restraining order case that they've already agreed to hear, and do sort of a low end, high end thing on, the limits of who can and can't be barred from owning guns under the Second Amendment. But maybe that'll happen. I don't think that's likely. What's more likely, because they're already through the period where they decided what cases they're going to take for the next session. And we're going to get a ruling in Rahimi. We'll get arguments this fall in Rahimi, and we'll get a ruling probably not until June of next year, because they usually wait until June to issue the most controversial ones. I don't know. It depends on whether the court thinks their ruling in that case is going to be controversial or not. Also, that's another tea leaf reading thing. They don't say that anywhere, right? The Supreme Court's not like, we're going to wait until it just so happens people notice that's when they tend to issue the biggest cases. The ones that have 5-4 split or 6-3 split or whatever. And so, because most Supreme Court cases, by the way, if people didn't know, are unanimous. These guys agree on most of these cases most of the time. It's just the particularly politically charged ones that end up being, the courts being split. But regardless, the other option is that they could take something on what people call the shadow docket, which are these emergency requests. That's sort of when you mentioned earlier those emergency requests in the Second Circuit case and the Seventh Circuit case to intervene in by the court, or even just the recent ghost gun case where the government asked the court to intervene on an emergency basis. That's what people call the shadow docket, because often they'll make decisions like they did in the ghost gun case to issue a stay or take some sort of action without explaining why they did it, and it could have really significant implications down the line. But you don't get an actual hearing, you don't get oral arguments, you don't get a written opinion from the court. You just get an emergency decision. So there's still that avenue to work on this stuff. I think it would be quite odd if they chose to bolster their Second Amendment case law this way, by just issuing unexplained shadow docket decisions. But that's another way that they could go.
Yeah, I think especially on something like an assault weapon ban, which is obviously a hugely hot button. You talk about controversial political stuff. And I highly doubt hardware bans, which is something that's obviously going to sort of be ripe and on the minds of a lot of Second Amendment lawyers and jurisprudence over the next few years, or however long it takes to get a final ruling. I highly doubt that they're going to issue that in some unsigned shadow docket opinion. So I wouldn't count on that. But where you might see something, one of our members asks, Weird Beard, by the way, great. Oh, actually, no, this was David. Sorry. He asked about the pistol brace rule.
David Rice he asked, what do you think? The pistol brace is, where's that case at right now, actually, first of all?
Yeah, so first of all, we had a series of injunctions issued by a district court, but he did not issue nationwide injunctions. In each of the cases, he limited the scope of those orders blocking the pistol brace rule to just the members of the individual gun rights groups that sued. And so that was then appealed to the Fifth Circuit, who took a look at the merits of the appeal, the merits of the injunctions, to a 3-judge panel of the Fifth Circuit. And they basically said that, in so many words, they think that this rule is likely not fit to stand and probably should be struck down, but they weren't going to overstep the bounds of the district court and issue that injunction themselves. So they basically spelled out for the lower court judge why they think that this rule is probably unlawful, and then they sent it back to him for him to issue a nationwide injunction, which basically just means please enjoin this so we don't have to. In which case, you could very well see a very similar.
And by the way,
oh, go ahead.
By the way, that's another common thing that you'll see in federal courts where they issue a ruling, but the ruling itself technically is to remand the case back down to a lower court for them to issue the final injunction or whatever. And it's like, technically they haven't issued an injunction here, but they've told the lower court to issue an injunction, and it's kind of the same thing. That's how I look at it, at least in terms of reporting on this stuff.
Yeah, that's a good point. Yeah, it's very, you'll see this a lot with federal judges. They're usually sticklers for procedure, and they give deference to the due process of litigation. So they allow, the proper judge to make the final call, which it's quite common. But what you're going to see, I think, in this pistol brace case, if the district judge heeds the judgment of the Fifth Circuit, you'll probably see a very similar trajectory to what we just saw with the so-called ghost gun rule, where, of course, DOJ is probably going to appeal any injunction against their own rule, right? It's their job to defend their rule. And they'll probably, depending on the Fifth Circuit's already indicated at least that they don't seem keen on staying it. So you could very well see that end up on the Supreme Court shadow docket, where they could be in a position to make a similar decision to what they made with the ghost gun rule. Yeah.
Although I would actually expect the Fifth Circuit to kind of take a hint from what the Supreme Court just did with the ghost gun case, and they'll probably issue a stay until they get to the final merits decision in that case. So
that's a good point.
But I do still expect that they'll make it all the way up to the Supreme Court the government's going to appeal that, just like they're going to appeal the ghost gun one. The government wanted the Supreme Court to take up the ghost gun case and skip over the Fifth Circuit altogether. The Supreme Court didn't do that, but that was the big ask from the government. And the fallback was to issue this stay, which the Supreme Court did. So I don't think there's any doubt that the government's going to try to take all of these cases, or maybe, it might not matter if they take up like the ghost gun case. It's going to be on the same basic grounds as the pistol brace case anyway. So that our decision in that case would be, would foretell whatever they were going to decide in the bump stock ban case or the pistol brace ban case too. So they might not just need to get one there, but I would expect they'd try to get all of them.